Morning, everybody. This is Tim Wilkins from the Bracewell firm, the Environmental Lands and Resources section, here to present another in the series of environmental essentials for in-house counsel. We have a great presentation today with Steven Cook on PFAS regulatory developments, in particular, cleanup, disposal, and reporting related issues. There is a whole lot going on in the PFAS universe right now, and we're going to focus on just this slice of it. For those of you who have not spent real time with this, I'm sure you've seen the PFAS in the trade press and the phrase forever chemicals in the regular media. We are talking about per and polyfluoroalkyl substances. These are widely used chemicals from Teflon to firefighting foams. They are persistent in the environment and believed to have significant health effects at very low concentrations. And so they are getting a lot of regulatory attention. We're going to talk today about some of the recent PFAS rulemakings, in particular EPA's rulemakings in the waste cleanup and reporting space. There are 4 specific rulemakings that I'm going to talk about. Steven's going to talk about some of the other key rubber meets the road actions that are being taken by EPA and other federal agencies. And we're going to just dive right in here. So the first of the 4 EPA rulemakings that we're going to talk about is a proposed rule. EPA published it in the Federal Register on February 8th to list 9 PFAS compounds and their salts and structural isomers as hazardous constituents. This is a sort of first step in regulating these chemicals. The state of New Mexico and some others had petitioned the agency to start the RCRA process with respect to PFAS chemicals. And EPA has, in this February 8th proposal, proposed to add those 9 PFAS compounds as hazardous constituents that will be listed in Appendix 8 to 40 CFR Part 261. That's the hazardous waste identification rule. Appendix 8 is a list of about 500 chemicals that get special attention under RCRA. This can be the start of a process to regulate them as hazardous wastes, for example. We're going to get into that in a second. The 9 particular PFAS compounds include PFOA, which is perfluorooctanic acid. It's a coating that is used to help make products resistant to heat, oils, waters, a lot of use in textiles. PFAS, perfluorooctane sulfonate, which is most commonly known for its use in Scotchgard. PFBS, Gen X, and 4 others, maybe 5 others. There are a number of these that have been added, 9 in particular, that have been added to the list of hazardous constituents, or they would be added in this proposal. The proposal reflects a conclusion by EPA after review of the studies that are out there that there are toxic, carcinogenic, mutagenic, or teratogenic effects. And the comments on that proposed rule are due by April 8th. What does this mean if we add them to the list of hazardous constituents? The proposal doesn't yet say, hey, this is going to be a hazardous waste. It doesn't say that PFAS compounds are a hazardous characteristic or a toxic characteristic. It's not listing them as hazardous wastes. It is, however, a first step towards treatment of these chemicals as hazardous wastes when they are disposed. It's a building block for future regulation. Crucially, right now, if it is finalized, it would add these 9 PFAS compounds, the constituents that require assessment and cleanup in any form of RCRA corrective action. And, you think about that, okay, I have a new corrective action come up, I have a new release come up, I have a situation at, my TSD facility where I have to do corrective action. Now I've got to address these 9 compounds in terms of the assessment that I'm going to do, in terms of any cleanup that I'm going to do. This, interestingly, is a backward-looking requirement as well. Even if you've got corrective action already underway, the rule as proposed and the underlying economic analysis all suggest that you're going to have to start looking into these constituents, even if your corrective action has already been defined, if it's in progress. It's sort of a reopening that would be required if this rule is finalized. So if finalized, the rule will add burdens to both new and existing RCRA investigations and cleanups. It will also start the ball rolling towards treating certain wastes as RCRA hazardous. That could be a very, very big deal in terms of how folks handle waste streams and wastewaters at their facilities. A RCRA listing in particular could be really hairy. PFAS is present in tiny traces in all manner of products and wastes. And because of the way that listed wastes are handled in terms of the mixture rule, if it is a waste that touches anything else, everything gets aggregated as a listed hazardous waste. By mixture, everything it touches becomes a hazardous waste. So listing will be a real issue if we get there. Second big rulemaking is what we call the statutory hazardous waste rulemaking. It's a companion rulemaking also proposed on February 8th in the Federal Register. In this proposal, EPA interprets its authority to address statutory hazardous wastes in corrective actions even without undertaking that Part 261 effort to list PFAS constituents as hazardous wastes or to consider them as RCRA hazardous characteristics. EPA is saying that RCRA, the statute itself, describes hazardous wastes as solid wastes that can cause mortality or illness or pose a substantial present or potential hazard to health if improperly managed. And therefore, those chemicals are already RCRA hazardous wastes, even if they have not been through a Part 261 rulemaking to establish a characteristic or to establish a listing. This is a theory in the law that's been out there for a long time. The case law, for example, in citizen suits, allows people to take an action claiming substantial endangerment from hazardous waste, even if it's not Subtitle C, Part 261 hazardous waste. There are, other theories out there as well that hazardous wastes can be quote unquote RCRA hazardous even without a formal listing or a formal 261 action. Interestingly, though, and hat tip to Steven here, Susan Bodine, the head of the Office of Enforcement and Compliance Assurance in the prior administration, points out that DOJ has taken a position against the state of New Mexico on PFAS litigation at the Cannon Air Force Base. DOJ has been saying that the state can't use the statutory definition of hazardous waste in order to access corrective action requirements and so forth. So it undercuts the rulemaking suggestion that this statutory definition is a longstanding EPA interpretation. What would this do? If EPA finalizes this rule, it would codify an interpretation that corrective action and other EPA response authorities dealing with releases to the environment can reach statutory, not just regulatory hazardous waste. Basically, it's saying you can issue orders and compel corrective actions for emerging contaminants, even though EPA has not already undertaken action to establish a characteristic or a listing for the material. It's basically providing a second bite at the apple for these 9 PFAS compounds from the companion rule, plus a lot of other emerging compounds that are out there, any of the hundreds of PFAS compounds that are out there. It effectively creates a case-by-case standard for what constituents are going to need to be investigated and cleaned up in RCRA corrective actions. And that really creates a risk that you won't have interpretive consistency as to what's a hazardous waste and what's not, what's subject to corrective action or not. It's almost an eye of the beholder standard. So that's really going to be potentially problematic. Initially, the proposal came out with a 30-day comment period that was just extended to 45 days. So March 26th is the deadline for getting in comments on the statutory hazardous waste rule proposal. So you've got time still to comment on both of the companion RCRA rule proposals. The third big action is the CERCLA hazardous substance listing. I think folks on this webinar are going to know what CERCLA is, but it's the Superfund law, the cleanup of releases of hazardous substances and the liability regime around that. EPA issued a rulemaking proposal in September of 2022 to add PFOA and PFOS as CERCLA hazardous substances. That comment period closed back in November of 2022, and this has been in a long period of review at the agency. We understand that the final rule had been generated at EPA. It has been in interagency review at the White House Office of Management and Budget since December 6th. So final rulemaking, publication in the Federal Register, it's anticipated soon, but this is one that's been heavily contested. There's a lot of concern that if we list these as hazardous substances without safe harbors for passive receivers of these kinds of things. Folks in wastewater treatment in those kinds of industries, landfills, are going to have lots of potential Superfund liability arising from these listings. So what happens if this gets finalized? First, it brings PFOA and PFOS contamination into the Superfund cleanups and into other programs that are based on Superfund or that use Superfund cleanup standards. This includes, for example, EPA's emergency and removal authorities. So if you've got a situation where, you've had a big fire and the aqueous foam has been used to put out the fire, you could have a lot of PFAS contamination at your facility, and that could be subject to Superfund cleanup requirements. That creates liability issues. It creates cleanup obligations. So that's pretty significant. What about reopeners at closed sites? Sites that have been closed for decades may have PFAS contamination that was never investigated and never cleaned up. Historically, it's been rare for EPA to reopen sites, but there is certainly no reason to believe that if PFAS is considered as dangerous as is suggested by this whole battery of rulemakings that EPA has been pursuing, that they would not at least ask the question of whether we should be assessing PFAS at closed Superfund sites, certainly at sites that are in process. The other thing that Superfund does, the other thing that CERCLA does, in addition to the cleanup authorities, is the release reporting requirements. This is, I think, really pretty critical here. By listing these chemicals as CERCLA hazardous substances, if you have releases to the environment, that's going to be reportable if the release is in excess of a reportable quantity. Because of the very low concentrations and the considered serious toxicity of these chemicals, EPA has set a 1 pound reportable quantity in the proposal for releases to the environment of PFOA and PFOS. This is going to be complicating. If that gets finalized in that form, you have the obligation to immediately report releases. It is difficult to calculate trace concentrations in materials that get released. And you add this very low RQ level of 1 pound, it's more common that RQ is going to be 1,000 pounds or something. You put that all together, and in an emergency incident, in a release incident, there's going to be a high degree of difficulty in figuring out if you have a PFAS-related RQ reporting requirement. So not just Superfund liability, it's reporting issues as well. This is a big deal. There are still conversations going in Congress about how to deal with potential exemptions or safe harbors from hazardous substance listing under CERCLA. There's bipartisan legislation that continues to perk along in the background, and those safe harbor ideas are key issues there. I understand there are, in fact, Senate hearings that are going to be coming up this month to address those issues. By issuing a final rule, EPA will sort of put pressure on Congress to take action if we need to do that. And of course, you can imagine that as to all of these rules, but certainly as to the CERCLA hazardous substance listing, if that goes final, there will be judicial review challenges under the Administrative Procedure Act. And that's going to happen like crazy if the final rule doesn't allow for common sense safe harbors for passive receivers. Okay, the last of the 4 big rulemakings here is under the Emergency Planning and Community Right to Know Act. This is the TRI program, and this is from last fall, October 31st. It is now an effective rule, and with TRI reporting coming up on July 1st, this is a deadline that's fast approaching. There are 196 PFAS chemicals now on the TRI list. These are considered chemicals of special concern, and they are automatically added to the TRI list pursuant to the 2020 National Defense Authorization Act. These 196 PFAS chemicals, because they are quote-unquote special concern, have a 100-pound threshold for reporting. That's where you, under TRI, manufacture, process, or otherwise use these chemicals. If you are doing that more than 100 pounds in a year, you're going to be subject to TRI if you're otherwise subject to TRI reporting. This is a real change from what is typical. 25,000 pounds is the normal threshold for manufacturing or processing, and 10,000 pounds for otherwise use. So 100 pounds is a really big deal. And again, this reflects the fact that PFAS often appear in trace concentrations. That trace issue is also important because frequently you're allowed to treat as de minimis the presence of TRI chemicals that are in, some raw material or some product at a concentration of less than 1%, or in the case of carcinogens, less than 0.1%. You could just ignore those very low concentrations for purposes of your TRI reporting. But because these are now listed as chemicals of special concern, they are ineligible for the de minimis exemption under that October 31st final rule. This also removes the de minimis standard for reporting up and down your supply chain as to the presence of PFAS in your products, in the products that you're purchasing from others. It's going to be a reporting burden in that sense as well, but it's going to create a need to really get in there and assess the presence of TRI chemicals, PFAS chemicals in your supply chain, and to make sure that you're properly reporting if you're subject to TRI. So really, please have some sympathy for your TRI reporters, because this is going to be a significant burden. And I would be asking myself, if I was running a company that manufactured chemicals or that handled these kinds of materials, are we resourced and ready for this? Because it's going to be a lift. One thing I would also say is that if you can't perfect this by that July 1st, 2024 deadline for reporting your 2023 reporting, you might want to consider doing it the way you've ordinarily done it, and then consider an audit and an EPA e-disclosure later in the year if it's going to take you a little more time to figure out if you've got this problem. All right, so I'm going to turn it over to Steven now to talk about some of the non-rule actions that are coming up.
Thanks, Tim. Appreciate that great overview of the recent actions. And I'd like to kind of start with an overview of there's three key legs to the stool when it comes to PFAS and the agencies. They got to have the legal authority to act, they need dollars, and they need technical capabilities to bring it all into effect. What you're seeing with these recent rules that Tim has discussed, EPA is creating the foundation for the legal framework and authority to take action. So now we're going to talk about some of their activities with regards to beefing up the agency's technical capabilities and understanding and the dollars that are going to impact this issue. First up is the PFAS disposal guidance. It is technically already overdue, as it's supposed to be updated every 3 years, and that deadline was December of 2023. It was sent over to OMB earlier last fall, but remains stuck there. What is likely occurring is further discussions between the Department of Defense and the EPA with regards to priorities for disposal and such and different practices. These discussions occurred when I was there at EPA as well. There are key data gaps and uncertainties exactly on disposal methods, and EPA has kind of flagged in various recent meetings to folks that they're likely to be, once again, disappointed if there's not definitive recommendations. And this comes once again from their lack of good data to be able to determine what is the proper disposal methods, particularly on the air side. Second, to increase their knowledge, EPA is focusing on a PFAS testing strategy under TSCA Section 4. They have issued test orders to various manufacturers. A new round is coming out, and this is an effort for them to look at representative compounds that they think represent the behaviors of a group of PFAS. And then we'll use that as a basis then to look at other regulatory actions they should take, the risk assessments they should perform, cleanup standards they could set. But this is an ongoing effort to fill in the gaps of the lack of knowledge with regards to the impacts of these compounds on human health and the environment. The next area of technical capabilities is testing methods. It's tough to make decisions when you don't have accurate data. And it's tough to get accurate data when you don't have accepted, replicable testing methods. And so EPA continues to work on developing test methods. It's one thing to develop a test method in a lab conditions with known levels of contamination and clean samples. It's a much more complex to get accurate data when you're dealing with groundwater that's going to have different levels of heavy metals and other compounds in there. Think about soil samples that'll have lots of different constituents, as well as the PFAS that you're trying to tease out. So extensive effort is ongoing to come up with those. There are efforts both on the private side as well as the government side to develop these test methods and get them accepted. And you're seeing those start to roll out and get accepted in the world, into the scientific world, which will then allow for data to be collected and for people to put some certainty in the results and confidence that they do represent an actual measurement. But once again, remember, we're talking in many cases down to the parts per trillion, even parts per quadrillion level. And so the necessity for being accurate and such is critical. And the cross-contamination issues and such are ever present. And that's something that EPA and others are continuing to work on. Finally, we have on here the Office of Research and Development, EPA, is developing a PFAS dashboard where they will catalog and make available all the different health effects studies and information with regards to each of these PFAS compounds as they become known. This is a consistent effort you see by this administration to make information easily available to the public and to communities. So you will see more and more efforts to put forth to the public information as it becomes available. The other aspect is they're looking at new approach methods, or NAMs, for developing risk assessments, trying to cut down what is typically a several-year process into a 1 or 2 years. This is something that needs to be very carefully watched. If you are an industry where a particular compound is of concern, you need to pay attention to how they are developing these approach methods, because these methods often will determine what the answer is. And it's something that you've seen. Those of you who have compounds that have come under EPA scrutiny recently, such as ethylene oxide or such, understand that the underlying science often and risk assessment can drive the regulatory approach the agency takes. So paying attention to how they develop this new approach methods will be critical for industry. Now let's talk a little bit about other areas to watch, and this gets a little bit more towards the funding side. Many states are already ahead of EPA in setting PFAS-related standards for cleanup. They have moved ahead in setting drinking water standards and such. So in some places, EPA is catching up to where states are. Some states have recently been raising the issue about, well, what about precursors and degradation in the environment? And that just adds more complexity to answering that always interesting question we have in the waste world is, how clean is clean? What do you have to measure? What do you have to clean up to? How do you determine that you've done it? Tim's already raised the issues about reopeners and going back. So as more test methods come out, as the technical capabilities increase, sampling of old sites, prior samples, prior areas you thought were done, can get relooked at. And we may come back to having to address, well, it was clean, but no longer is it clean, but we got to re-clean what was clean. Also, you should pay attention to the litigation. If you're obviously a participant in it, you're well aware of these cases. But if you're not, they're going to impact how fast this whole issue gets moved forward. There's a multi-district litigation down on the federal court in South Carolina where all the cases involving aqueous film-forming foam, or the AFFF cases, and contamination from those were all consolidated. And they've been moving through bellwether cases and discovery for several years. And recently there's been settlements with the manufacturers of certain of these compounds, namely 3M, Chemours, DuPont. And over $12 billion are being finalized. Those will go out to purveyors of drinking water sources. And there's two groups. There's a group that already knows they have contamination. Then there's a group that doesn't know yet. But as these funds get out to these systems, they will be doing more testing and sampling. They will find PFAS, as has been so far consistently found. When you sample a lot of areas, you will find PFAS in at least some of those. That will then lead those drinking water systems to not only get funds from this settlement, but others may be looking at what is the source of the PFAS that came to the drinking water source. That will then lead to on future litigation with those. So you might think about the asbestos context. First, you had the manufacturers of the asbestos, then ultimately it led to cases against premises liability where people had asbestos and insulation at their chemical plants, refineries, and such. The same kind of cascading litigation is likely to occur as more and more sampling is done. PFAS is found in more and more locations. And these kind of settlement funds, as well as money that's been available under recent congressional authorities that EPA is doling out to environmental groups and such, more PFAS will be found in more locations, and that will accompany more litigation. Finally, you're seeing consumer product companies right now are being targeted for claiming they're PFAS-free when they may not be, or other green claims. But once again, this cascading effect, there's going to be more and more litigation pressure to understanding where PFAS is in the supply chain. The consumer product companies are being pushed to identify and eliminate PFAS in the supply chain, and you will see this happening in more and more areas as this go along. Finally, we come to the largest PRP when it comes to PFAS, and that's the Department of Defense. I think you ought to think about them as the largest PRP. They are literally dealing with hundreds of different locations where AFFF was used either in training or in putting out fires, not only in the U.S., but throughout the world. They are under pressure from Congress to eliminate PFAS, and particularly the AFFF. That's why you see in the annual NDAA Act, there always are PFAS provisions now in there. It's related to Department of Defense, but you see it can drive activities by EPA beyond just the Department of Defense. So paying attention to what DOD is doing is important. In the multi-district litigation, they're asserting a CERCLA 113H defense, saying they are following the NCP, the National Contingency Plan, and doing their cleanups, and therefore the 113H litigation bar on the level of cleanup and the type of remedy ought to come into play. And so they're trying to work around getting a court or the plaintiff's bar being able to set how clean is clean and say, we're following CERCLA, we're doing our part, and we will continue to do so. And in fact, in CERCLA, there's actually a defense environmental restoration program that was set up in the 86 amendments that they are following. The other thing to think about from Department of Defense is they have a lot of money. And because the contamination is at bases and is affecting those serving in the armed forces and the nearby communities to those bases, it gets a lot of political attention. So they are assured of getting funding through this process. I know from personal experience that when you have these types of high-level interest from the politicals, when your government phone number is in speed dial of certain U.S. representatives, it heightens the level of interest. And so DOD is spending a lot of time and money on developing sampling techniques in conjunction with EPA and separately from EPA, how to do more testing, how to different remediation techniques. They have the funding to do this. They have the political will to make sure it gets done. And so they will likely be setting the precedents for what the private sector will have to do as they go through and clean up their issues at their various bases. So it's worth paying attention to what DOD is doing if you want to kind of get a view of the future. So I want to leave you with this final thought. The recent actions by EPA indicate they have a willingness to go to zero, meaning that the practical considerations that prior administrations, not just the last one, but the one before that and before that, EPA has always been hesitant to go to ultimate bans or zero. Lead's a great example where nobody can say that there's a safe level of lead, yet there's not a zero for the cleanup standard of lead contaminated soil. There wasn't a zero in drinking water because practically nobody knew how to get there. With PFAS, with the way they are setting the levels so low that they're below detection levels, which means they're essentially zero, this administration's EPA seems to be willing to go to zero or bans. And this affects what they'll set as a regulatory standard. So if you think that they're willing to go to those really ultra low numbers, essentially zero, your understanding where PFAS is within your products, your supply chains, usages at facilities, and potential substitutes is going to be critical to your successful management of the associated PFAS liabilities. So whether you think about using audit provisions or other investigatory tools out there, understanding where these chemicals are in your supply chain and at your sites is going to be critical to be able to come up with a management strategy that makes sense. So with that, Tim, I'll turn it back to you to wrap up.
Hey, thanks, Steven, for that. I really just want to thank everybody for attending today, for participating in our Environmental Essentials webinar series. And I want to also invite folks to join us in Houston. We've got our semi-annual seminar on environmental law issues coming up on May 8th. Again, Houston office, May 8th, 2024. Please save the date, and we'll look forward to seeing you there. Thanks, everybody. Appreciate your time.